Today I'm going to be talking about author rights, and my name is Jackie Werner, and I am the Scholarly Communications and Research Librarian at the Philadelphia College of Osteopathic Medicine. So if this is your first scholarly snippet, welcome. This is a series to help you advance your research skills and support your scholarly activities. All presented by osteopathic librarians. And today's workshop will help you identify who holds the rights to your published work and how you can negotiate for them. All right, the first question. When you publish an article, who has copyright for your work? Now, you might think that if you've written something, you and the other authors would automatically have copyright to it. However, this depends on what agreement you sign with the publisher. Here I have two articles by Dr. Dianzhen Zhang, one of my faculty members. This one was published in the journal BMC Medical Genetics. And over here, you can see that copyright belongs to all of the authors of this article. However, another article by Dr. Zhang was published in Cancer Letters. And here the copyright belongs to Elsevier, all rights reserved. What does this actually mean to you? Only the copyright holder can make copies of the work, publicly display the work, distribute copies of the work, make derivative works, and control how the work is used. So, say for instance, you've written something and you want to put it up on your own website, or you want to put it up on ResearchGate so other people can see it. If you do not own the copyright to that work, you are not allowed to do that. You can't put what you've written up on your website, your school's website, and so on. So I'm going to go over how to know what rights you have. And this is a really important thing to know before you decide to publish somewhere. If you'd really like to keep the copyright to your own work, then you'll want to know the policies of whatever journal you're looking at before you start publishing. So the first place you want to go is called Sherpa Romeo, and it's a resource that aggregates all policies about copyright and open access, which I'll go into in more detail shortly, but is basically the ability to make your work freely available on the internet. And here I looked in Sherpa Romeo, and you could search for any journal by name or ISSN or the publisher in general. And these are some of the rights for Cancer Letters. There's about 9 different possibilities in here. I've zoomed in on the accepted version of the paper, and this shows that you can post that in with a 12-month embargo, with a specific Creative Commons license, in a non-commercial institutional repository and subject repository, and with the conditions. I'll go over this in a little more detail later. But basically, it looks at every step of the article, the published version of the article, the original version of the article before peer review, and the accepted version of the article where everything is finished, but it's not formatted. And Sherpa Romeo also includes just links to where all these policies are on the publisher's website, which is a very useful place to have everything gathered in one place. And as those links suggest, you'll also want to just look at the publisher websites. So I went back to Cancer Letters and looked at I just Control F, search for copyright within their publishing agreement page. And that these publishers should tell you exactly who has the copyright and whether there may be exceptions, how you get those exceptions, and so on. Next, I'll go over how to negotiate your rights. So, it is not set in stone that a publisher saying that they own the copyright to what you've written means that it completely belongs to them. The first thing here, the Spark Author Addendum is a legal instrument that modifies the publisher's agreement and allows you to keep key rights to your articles. Publishing agreements are negotiable. It's not absolutely necessary to sign over copyright to publish in the journal that you're really interested in. The author addendum just gives you a legal framework, and you can just say, you could just like print it out, give it to the publisher and say, these are the rights I would like to have. And of course, they're not always going to say, okay, but the backing of Spark and its legal knowledge is very useful in giving somewhere to start negotiating. Next, something very important when you're negotiating rights. You want to keep your preprint and postprint. So I showed Sherpa Romeo back there, which explained that the accepted version or postprint was allowed to be published to an institutional repository, 12-month embargo, and so on. Most publishers will allow you to post some version of your article for free, even if they own the copyright. But it usually is not the published and formatted version that you'll see in the actual journal. So here's an example of a postprint, post peer review, but pre-final publication. And as you can see, this includes comment boxes, copy editing marks, and line counts. So that's a good way to tell that you're looking at a postprint instead of a final version. And if you keep these documents and have them actually labeled as to what they are, it means that your chances of being able to post your work available where you want it goes up a lot. And the final thing you could do when you're negotiating your rights is to consider publishing open access in the first place. So what exactly does publishing open access mean? There are two major types of open access. Green open access is what I just talked about, where you can take an article published in a different journal where you've already signed away the copyright, and you could make that available for free. Now, you need to follow journal procedures for this. Once again, you can't just put it on ResearchGate. So go to Sherpa Romeo and look up what it says for accepted manuscript or initial manuscript or submitted manuscript. And you'll probably be able to post your article. The other type of open access, which is really worth keeping an eye on if you're interested in keeping author rights, is gold open access. And in gold open access, your article will be published as open access from the very beginning. As soon as it goes online, it is freely available. And usually this means that you will have the copyright to it. So going over gold open access journals. Some aspects of them the author almost always retains the copyright. And multiple authors, all of you will have a joint copyright. That means that you can post it where you want. And open access journals, many are comparable to non-open journals. So it's not like kind of settling for something for a worse journal, but that has better author rights. If you look at, say, the impact factors of journals, a lot of these open access journals are going to be right in there with the traditionally published journals, the ones that have been out before the internet was even a thing. And unfortunately, many of these require author fees to publish, because if they are not getting money from subscriptions, then they need to get money somewhere to actually pay their editors, copywriters, etc. And so that means that the author will have to pay to publish. And this does not mean that it's a scam, even though it kind of sounds like it. It is, this is a valid way for these journals to continue existing. And in our final slide, I link something called the Directory of Open Access Journals, which looks over open access journals and makes sure that they are not scams, that they're actually good journals. And you could also see a lot of open access journals are included in PubMed and Scopus, etc. Here I've given some examples that the library at PCOM is partnered with, and that's Biomed Central. Oh, that should say BMJ Case Reports, or Public Library of Science. And let's go over Creative Commons next. So, along with most open access journals giving the author copyright, you will also have a Creative Commons license on your work. The most important thing to remember about Creative Commons is that it's an addition to copyright. It does not replace it. So why would you use a Creative Commons license? That's if you want to make your work freely available, but you still want to maintain control over how it's used. For instance, you have the copyright on this work, so you want to allow anyone to read it, but you don't want them to, say, take your name off and pass it off as their own. So all of these licenses, except the first one, which is a special case, include the word include by. And that means that for every one of these licenses, whatever other rights the licenses give you, you have to attribute it correctly. You have to say this is by these authors. And besides that, there's a big variety of licenses where you can mix and match exactly how you want things used. So, for example, down here at the bottom, we have CC BY NC ND. NC stands for non-commercial. If you don't want anyone to use your work for commercial purposes, say, grab all your open access papers together in a book and publish it. ND stands for no derivatives, which is really more important for kind of creative open access things like artwork and photographs, where you don't want anybody to edit it, draw little devil horns and pitchfork on it. Also, there is share alike, SA, which means that whoever, whatever they do with this work, if they're putting it up on the internet, they have to use the same Creative Commons license. And finally, we have the first license, CC0, and this is just the same as public domain. This is actually giving up the copyright to your work and saying that no restrictions, anyone can use this. You usually don't want to go this route unless you're, say, working for the government, which there was a question about that. I will answer that later. And now I realize that I had all these descriptions on the next slide. So here is a nice little chart going over everything that I talked about. And you can see that under CC0, or public domain dedication, it says specifically that the creators have waived all their rights to the work worldwide under copyright law. That does not apply to any of the other ones. So if you worry that putting your work out under Creative Commons license is going to give you less legal support than not doing it, that is absolutely not the case. You still have the copyright and you still have the right to attribution and whatever else you put in your Creative Commons license. And my final slide is just, well, almost final. When in doubt, ask a librarian. Copyright and author rights are a really tricky thing, and they can get complicated, sometimes with legal jargon from publishers intentionally be complicated. So that's what we're here for. If you have specifically a research or scholarly communication librarian at your institution, or even better, if you have a copyright librarian, then we're used to working with these type of situations and figuring out what is best for you. Otherwise, you can talk to your liaisons or subject specialists, or just email the library in general and ask, who do I talk to? All right. We also had some questions that were emailed in when you all registered. So let's go over those. The first question is, what author rights do government employees have? So that is a complicated case. When you're writing for the US government, or everything the US government publishes is automatically public domain if all the employees are government employees. However, this does not apply to people working at specific US government institutions, such as the Naval Academy, who are publishing in a journal. So the answer to that is, it depends what you're publishing and where. If you are, that would be something to really talk with your librarian there. And the reason that say your works could be automatically public domain if you work for the government is that a lot of your author rights can depend on your on where you're getting funding. For instance, NIH grants are requiring all research funded by that grant to put their work out there, open access. And many, if you look in Sherpa Romeo, many different editors have special notice. If you are funded by the NIH and required to make it open access, then you can make it open access. Otherwise, All right, and next, there was a question about who can claim a university affiliation. Can adjunct faculty and preceptors claim a university affiliation? Is this a common practice across most institutions? And the answer to that is it's really up to you. From what I could find, there seem to be no best practices about that. The most common thing is that you list as your affiliation where you did the research. So if you're an adjunct at PCOM working with other PCOM full faculty members, then just list your affiliation as PCOM. And you could do that if you want and you're not affiliated with anything else. You can list that as an affiliation if you haven't, if you didn't do the work there. But you can also just list yourself as an independent author. You could also include a footnote saying where the research is done if you would rather mark your affiliation. Just say that you're independent. And the final question was, does the author's address have to be the same as their affiliated institution? No. A lot of the times we have, we'll have people publishing, and their email will just be a Gmail address. The one time you want to be careful, though, is if you're submitting a paper anywhere where your institution has a publishing agreement for paying open access fees. So, for instance, here at PCOM, we have an agreement with Biomed Central. And there, if our author put in just a personal Gmail address, then BMC would not know to bill us, even though they put their affiliation as PCOM. They really need that email address to be an institutional email. All right, so we're about ready for questions. And before that, I'll just put up, I have a list of links here, Sherpa Romeo, everything I talked about, and part of the copyright code talking about government employees.